So, Sarah, you run a lot of the coverage investigations on our cases. So, explain to everybody what comes next once you realize that a case comes in and it's got a $50,000 policy.
Yeah, so we've kind of developed a to-do list going down the checklist of where to look to run down additional coverage. The first thing you do is look for the owner of the car because the driver might not be the owner. And in Kentucky, typically the policy follows the car. So if you get the driver's insurance, it might not be the applicable policy. Next thing you do is get your own client's insurance because they would have underinsured or uninsured if the driver or the owner didn't have any insurance. You kind of hit the ground running, investigating, looking for any other umbrella policies that might be out there. For example, like you said, driver might have $50,000 in coverage. Our client might have $100,000 in medical bills. Their UIM might only be $25,000. So there's a gap for that extra $25,000 in medical bills. And so if, for example, you find out the driver or the owner is a large company, they might have an umbrella insurance coverage on that car or the driver. One specific example that I can think of, we had a client who was hit. He had about $50,000 in medical bills. We found the policy. Driver only had $25,000.
Yeah.
There was a company listed on the police report. We tracked down that company. The police officer had written the company's name down wrong. So we went to our client. We said, "Hey, do you have any pictures from the accident?" He sent us over pictures, and the name on the truck was a different company than what was on the police report. Yeah. We get in touch with that company. The insurance then turns out to be $1 million policy. So we were able to expand that coverage in that way.
So you mentioned umbrellas, and I think the more we do this, the longer we do this, the more often we find umbrella coverages, right? Umbrellas are cheap these days. And so it always surprises me how often a case will come in and we've got low limits, but then if you investigate and you push a little harder especially with these adjusters that don't just come out with the information voluntarily, right? You end up finding that more people than you would typically think have umbrellas, right?
Right. Yeah. In a typical umbrella policy, what we're seeing nowadays is sometimes $5 million.
Sure.
And so you got the $1 million of the liability underlying and then a $5 million umbrella. And so that opens up recovery for the client that an adjuster might not want to hand out at the first glance at it.
Yeah, I remember a case you came to us with, and we had $100,000. The adjuster had told the client and their original attorney that there was $100,000 limits, and if they would just get over medical documentation to document the injuries that were being claimed, they tender the limits. And then they come over to us because it wasn't enough to cover their injuries. And what do we find but an umbrella?
Right. That was the example I was thinking of. Yeah. I think it had a $5 million umbrella that we were able to uncover and hopefully recover for the client.
Sure. And how often do you think that these days, especially that the first amount of coverage that is apparent ends up being all that's available?
When we were first looking at a lot of these car wrecks, it kind of looked like what was on the table, the policy was it. But as we've been doing this more and more, like you said, it turns out probably, I don't want to give a percentage, but we've had several cases in the last year where we've uncovered multiple umbrellas and additional policy limits for the clients.
Yeah. And that's just not fair, right? If you don't know where to look and you don't know what buttons to push, you may not find out that there's additional coverage available for your client.
Right. And finding that additional coverage is a skill. It's not luck.
Right.
The reason we like to open these coverages up for our clients is we are seeing more and more cases where the injuries clearly exceed the limits, right? That are disclosed by the insurance company. And I think one thing we have to talk about is it's illegal for the insurance company to misrepresent limits. Kentucky law clearly states they have to tell us what is available, but does that always happen?
No.
No, it doesn't. I mean, and that's the problem. So when we have colleagues out there that call us to come in for some assistance, or a client calls us for additional assistance, looking at these different coverage angles from, like you said, from driver to owner to UIM to no fault coverage to other claims that may be available. If we're not truly digging deeper and going deeper and just taking the easy money like many people do, then I don't think we're doing our clients a proper service, are we?
No, definitely not. And look, it's not fair, but it matters the way you ask the question, right? And that's it. If you don't ask the right questions to insurance companies, you're not going to get the answer. They're going to answer the question that you asked, and they can skirt around issues that way.
A great example would be an adjuster writing us an email to say, I am offering the limits of $1 million, not all available limits, right? And so our demands are specifically tailored to demand all available limits, not the limits the adjuster is disclosing, which means there could be other insurance. So if Progressive offers us $1 million, Lloyd's of London may have an umbrella policy that they haven't disclosed. So not only are there additional limits, there may be different insurance carriers writing those limits, which is why we have to use that additional language for all applicable insurance policies, not just Progressive's insurance policy under my example.
Yeah, it's amazing how many times after you say, that's fine, we'll accept your limits as long as that you send over affidavits of no additional coverage accompanying that limit, and then all of a sudden they find additional coverage.
Yeah, you put them under oath and see what happens. Yeah. Right, so it works.
All right, so now we found the coverage. Now we got to prove that the case is worth it. Justin, that's the other half of this, right?
Yeah.
So an attorney has a client with $200,000 in medical bills. What's that case worth?
Right, exactly. And what I would tell any client is that if an attorney answers that question without any additional information, you run as fast as you can, because that attorney is either lazy or lying to you, because that is what most attorneys do, is they take the medical bills and they just want to evaluate a claim based only on that. The trick of the trade and what we do is we dive in to make our client not just number 1086 to the insurance company. We're trying to personalize them to the insurance company. So you got $200,000 of meds, but how did it affect your life, right? And the example I give all clients is, if I break my arm, I can go into court with a sling, right? A roofer, he or she may not be able to do their job with the same broken arm. So not all injuries are equal. Not all medical bills are equal in that regard. So what we do and what we instruct our team to do, Masten, is we have to get to know our clients. We have to personalize this terrible situation that they've been involved in. Do you have children? Is it affecting your ability to play with your children? Is it affecting your ability to work? Are you a coach on a team? Right? There's no line item at a jury to say you missed out on coaching, right? But it is part of the analysis. It's part of the mental anguish. And that's what we have to do, is dig down and get to know our clients better.
Yeah. And so once we get to know our clients and we're trying to figure out how to personalize the demand and personalize the damages, there's things that go into our damages architecture, right?
Yeah.
And so can you talk to everybody out there listening, what comprises our architecture?
Yeah, and I love that you use the word architecture, because it really is putting this professional piece together, because we're not just looking at medical bills. We're looking at what's the future hold, right? So we have to get experts to tell us what the future is likely to hold for this person. We have to go to vocational economists to see what type of lost earning capacity this person might have. Can they work again? Can they still do that trade? Under my example, if you have this really bad injury and you're a laborer, you may not be able to do it. But if you're an attorney, you may be just fine, right? And so, again, it's personalization. It's looking at the day in the life of these people, getting an understanding of how they've been affected, as opposed to just, I've gotten 200,000 medical bills. Because we all know that's what a lot of attorneys do, right? Here's your medical bill, you're up 500,000. That's what your case is worth,
right?
Without really understanding or getting to know their client.
And so, in order to put together all these pieces and parts, right? Like, we hire other professionals,
experts,
to assist us, right?
Absolutely.
We got life care planners.
Yep.
Economists.
Yep.
What else?
Well, physicians, obviously, the specialists that are going to give us what the medicals are, and our attorneys personally meet with these people. I think that's the big difference too. Is we're not just relying on just what the medical record shows, because medical records can be inaccurate sometimes. I really think it absolutely comes down to personalization. It absolutely comes back to the experts, and it's just putting yourself in these clients' shoes to start appreciating what they're going through.
So when we're developing our expert proof, right? So Sarah, Kaci, you guys deal with these experts on a daily basis, from the life care planners to the day in the life videographers to our economists. What does that expert workup look like, and more importantly, what does it cost?
I was emailing an economist this morning, and so the workup, they take a look at the medical bills. They take a look at if there are any physician opinions on if this person can't work for the rest of their life, or if their work life has been diminished by however many years. They take a look at all those numbers. They look at their taxes, their tax returns, what they do on a typical day. And they put, that's more of a, what's Ralph Crystal? Vocational. Thank you. Yeah. So, and we also work with vocational economists too, who take a look at and can give opinions on if this person can work in what capacity that might be diminished.
Right.
Yes. And so they take a look at all of that, and then they put a number on it.
And that's important because, we all listen to ourselves, right? We think we're the end all be all, the experts that people want to hear our damages and they're going to accept it as gospel. But that's not true, right? The adjusters and the defense lawyers and the juries need to hear it from these experts, right? And so when we do this workup, it worries the experts, worries the adjusters, it increases the value of the cases because they know we're going to be able to put on testimony at trial, right?
Yeah,
right.
For sure.
And we take an approach where we're pretty open with our experts that we have, and we give all of that information just from the jump to the adjuster.
Yeah.
Because it wastes time if you wait and try to, surprise them at the end with this big number. It devalues the case for your client. So once we get that report, we typically just, send it off and say, hey, this is the proof that we're going to put on, tender your limits, or, tender whatever our demand is.
Yeah.
So.
And, Kaci, I've noticed that a lot in some of your nursing home cases where, we'll be beating the drum to an adjuster or defense counsel about what the value of the case is. And until you get the expert stuff over to them, they're just not listening.
Well, and I think unfortunately that's because a lot of nursing home residents are treated all the same. And so they get a file and they're like, we've seen this case 47 times. What does this mean to us? And so when we engage that expert, they stand out a little bit and they become more unique and they see the value of the case in a way that we haven't been able to convey before.
Yeah, absolutely. And until I started working with you guys, I had never seen someone spend so much money so early in a case on experts.
Yeah.
And you and I have talked about that many times, but the return on that money is exponential. So when we're talking about expert cost, the expert cost can be extreme in serious cases because the number of experts, we're talking about reconstructionists, we're talking about human factor experts, vocational economists, medical experts, nursing home experts, whatever it might be in order to advance the case. But the reason we spend so much money on that is why.
Right, because of the return. And you're exactly right. We were talking about the other day, and we have cases. Here's the business issue with the way we do it. A lot of people, and no fault of their own, it's just the way the economy works, is a lot of people can't afford to carry those expert costs through the end of the case.
For years.
And so what they'll do is a lot of folks out there, and again, no disrespect, but they will wait until the very last minute to retain their experts, to get all that proof in the bucket, so to speak, because they can't afford to carry the cost. We have two cases right now I'm thinking of that we have over $500,000 worth of costs on expert fees in each case. We're early days in these cases. We're not expecting to see resolution for, a year to 18 months. We're carrying those costs for that year to 18 months, but that's better than it is waiting until right before expert disclosures are due.
Yeah, because the return comes quicker for the client. You see a larger return for the client. There's absolutely a exponential return based on what you spend in a case. I think there's no question about that. But like you said, there's a lot of attorneys that are afraid to do that or just simply can't afford it.
Yeah.
And they're never going to tell the client that in intake, and that's okay.
Yeah, sure.
They have to come to us, or they have to come to an attorney who's going to spend that money. So.
Now, we got to be honest though, right? Have any of you, Kaci, Sarah, Justin, have any of y'all ever experienced a case where you spend the money but you don't get the return?
Not yet. I'm sure it'll come someday.
Yeah.
But not yet. I don't know. Have you lost? I haven't lost yet.
No,
Oh, okay.
sure have not.
So, but it's slightly different than losing, because you're right, we don't. But has there ever been an instance where you spend $50,000-$60,000 on experts, and just because of what is available or other issues that come out in the case, you don't get the return on that case that really, with hindsight, you couldn't justify the 50 to 60 grand you spent on experts?
I think we are pretty conscious about the case and our valuation of it, and whether it's worth that expert expense at the beginning or not. There are thousands of experts out there. Some cost more than others, and so we might get a case in and say, these are your injuries, and yes, you were significantly hurt, but you didn't have to, have 18 surgeries. And so we might send it to an expert who's a little less expensive, but still get that opinion back and be able to put more money in the client's pocket than sending it to an expert that might cost $50,000.
Right. And that's part of the experience factor too. So it's not just the cost of the expert, but it's which experts do we need, right? Because in some cases, liability is not disputed, and we get the insurance adjuster to admit liability. So there, we don't need a recon, we don't need human factors, so we just cut out a $50,000 bill for that case. But what is contested are causation of injuries.
Right.
And so we have to focus our dollars on causation of injuries, because that's where the fight's going to be. So I completely agree with you that putting the dollars in the right place based on where the fight's going to be, that's also a skill, for sure.
The other day, I know we were all talking, we had an issue come up, and I initially said we need these two experts, and both of you all looked at me and said, no, we just need one. Why would you invite additional cross and additional
it's
rebuttal
strategic too.
experts,
Yeah,
right?
that's a good point.
So there are times where we may go hard thinking we need all these experts, but after we all talk about it, we reduce the number that we need. But again, we're not afraid to hire all of them.
Yeah.
Kaci, have you ever run into any issue where you wanted to get an expert in a case, but the case couldn't support hiring of an additional expert?
Yeah, I think that goes back to understanding your client really well and understanding their damages. And like Sarah said, your client can be very hurt, but their medicals are not very high. And so we can go about other ways to support those damages. And maybe the case doesn't justify the expert cost, but we have the resources available to us to show those damages in other ways.
A lot of times when we're negotiating a case too, and that very circumstance arises, we'll call the defense lawyer and say, listen, you guys know that we'll hire these experts. You guys know that we can do it. You guys also know that this case probably can't support it, but it's going to make it more difficult on you all. So can we get it to a resolution now, or do we need to go ahead and hire the expert? And because they know we'll spend the money to hire the expert and eat the cost on at the end of the day, we probably get to a resolution. Right? A little bit faster.
Yeah. Strategic communication is so important in these cases to ensure that we're maximizing what the client takes home is what we're ultimately talking about, is how do we maximize that? And that's exactly how to do it, is to communicate with the team, communicate with our client, get an understanding of when resolution is important versus when hiring those experts are important.
Right. So, it's not fair sometimes that a solo practitioner can't afford the $60,000 on a case that might not resolve for 3 years. That's not a criticism for solo practitioners. It's just math. But, if we've got two clients with identical injuries and wildly different outcomes based on who picked up the phone, that's not fair, right? We got to make it fair for our clients. That's what we're doing things for. So, Kaci, you live in the first 90 days of these cases. Tell us what those first 90 days look like.
It's a very, very broad question, but I think...
Now I'm being cross.
Can you maybe ask a better question, sir? Yeah.
I feel like I was going to name a defense lawyer that can ask questions, but I won't do that.
Can we break apart the 90 a little?
Sure.
Okay.
Yeah, go ahead. Just answer the question you want to
Just
answer.
say there's going to be a lot of info. God,
When a case is initially filed, Kaci, what does it look like on your end? What are you doing?
Yeah, I think the most important thing is to get the lay of the land and understand your client's claims, because the first big thing you have to consider is statute of limitations. Is the clock is always running, but how much time does your client have by the time they get to you? And so that's a big consideration. A lot of times we're looking at 2 years, and maybe your client didn't come to you until a year and a half in. And so understanding the time that you have to kind of build your case before filing is critical.
Yep, agreed. Agreed. What does that communication look like with the client? What are the things you're asking? What are you talking about once it gets to you in litigation?
A really good starting point, obviously, is going to be the date of injury, the date that they started to notice other things that have happened pertaining to their injuries. And we're constantly just trying to understand the incident as fully as possible. Descriptive words, what happened, where were you, who were you with, and just unpacking that with as much detail as possible from the jump.
Right.
So, and you said we a lot, right? Yeah. So in these first 90 days, how many people within our firms are touching these cases?
There's absolutely nothing we're doing on our own. We have an amazing intake team. They're probably talking to 3 or 4 people from the jump. Then they're going to make contact with the attorneys. I mean, I think we all kind of talk about cases as they come in. It's truly a team effort. I'd say you're probably meeting about 10 of our team from the intake point, 10 members.
Yeah, and just because one of you or one of us is the point of contact attorney, that doesn't mean that's the only attorney working on your case, right?
Yeah, and I think that's the big key thing in our practice is every single attorney is available to talk about every single issue. And so I might call the client and tell them, X, Y, and Z, but I've talked to 3 other people and they've given me their perspectives and their experience as well.
Mm-hmm. So what's the thing that you think referring attorneys most commonly haven't done by the time the case gets to us?
I think a really good example of this is you think you get a client, you think you understand what had happened, you think you understand the incident fully, and you don't send preservation letters. You're not making contact with people that might have information you're going to need later because you think you understand the case. And so evidence can get lost, destroyed. You think about video footage, that stuff's not maintained very long, and that can be gone forever. And so...
I mean, look, that is so important because I'm telling you right now, if you have a case and you have not sent a preservation letter, do it now. It's free. From that point on, it gets expensive.
Yeah.
Send the preservation letter.
And, you'd rather send an unnecessary letter than lose evidence forever. So the risk is minimal.
It's amazing how many attorneys will sign up a case and conduct almost no investigation. They'll go get the medical records because they're looking at a medical bill, right?
Yep.
But very little investigation has been done into that case. And so I think that's kind of what you're describing right now is having to pick up the case, not from scratch necessarily, but most certainly from an investigative starting point, right?
Well, and even with medical records, it's not always clear everywhere that your client has treated. They can describe they went in an ambulance ride and they went to the ER, but did they go see a specialist? And so you need to really understand where all they treated.
Yeah, of course.
And so during that investigation, we're trying to figure out the facts and figure out the damages. Sarah, are we also investigating coverage at that time?
Typically, yeah. The answer is yes.
Yeah.
We are investigating coverage at that time. These run parallel. And so because people disappear, there might have been a third driver who hit the car that hit you. And for some reason, they, disappear and you can't find them. So you want to try to track down every single applicable policy as fast as you can as well, because it's much easier to deal with insurance companies, as we know, than a random driver who hit you and disappears.
They're required to put them on notice too. I mean,
Right.
How many times do we get into a situation where an at-fault party doesn't put their carrier on notice and the carrier comes back and tries to say, well, we weren't put on notice, therefore no coverage.
Exactly.
So I think we have an obligation for our clients to hop in front of that as well,
Yep.
So I guess let's talk about the part that nobody wants to say out loud, right? Like what actually happens.
I thought you were going to say something totally different. Go ahead.
That's for next.
Okay.
next month's episode.
podcast. Okay.
Right. So, but what actually happens to a referring attorney's relationship with their client and their fee when they send us a case? Right? Like, I mean, is that referring attorney losing the fee and losing that relationship forever or what?
It's case dependent. And I've heard you on the phone telling attorneys you can be as involved in the case as you want to be. And that's kind of our policy here. But it is case dependent. If the attorney wants to send us a case and then have nothing to do with it and just work out, a fee, a referral fee with us, great. If they want to send us a case and keep working on it with us, we do that too.
Yeah, and you're absolutely right. We have lawyers that send us cases weekly, right? And everybody's different. Everybody has a different way they want to be involved or not be involved. Some of them just have clients that they say to them, I don't handle these kinds of cases, but I know who does. We trust them, blah, blah, blah. Or they handle these cases, but as we've been discussing, they just can't afford to handle this particular one.
Right.
And so they can confidently say to their client, listen, I'm going to stay involved. I'm going to be your point of contact. I'm going to litigate this case, but I need help. And so we're going to bring these guys in. And so what I think is important for referring attorneys to understand is you can do that. We will work with you to figure it out. The rules provide that we get to do that. It used to be, right, like if you were going to take a fee, the fee had to match the work in which you were performing.
Right.
Anymore, that's not it, right? I think the rule specifically says that the division of fee either has to be in proportion to the work performed, or it has to be by agreement, and the client has to be aware of it. And so when Peterson and Whiteford handle cases together, we have our deal, and that's why we are able to offer these services as our joint venture to all of our clients. And it's the same for a referring attorney, right? If you want to be involved, great. If not, then look, we're advising the client you're essentially getting 2 firms for the price of 1, and in the circumstance of a referral, you're getting 3 firms for the price of 1.
Right.
So, Justin, we're talking about how these referral relationships and how the relationship works with the lawyers and the client.
Sure.
Like, what's the perfect referral relationship look like to you?
Sure. The perfect referral relationship is handling it in a manner that is the best for the referral attorney. And what I mean by that is if it's a young referral attorney that truly wants to learn,
Yeah.
it's a great place to learn, to be a co-counsel with us, to see how these things are litigated, and to truly be on the inside of how the sausage is ultimately made, right? If it's an attorney and they're on their last leg and they're taking a few clients here and there, they've given up their office, they're working out of their house, and they just, they want to refer us a case and just see a result, that's a great thing to do too. And as you know, we take a lot of those. We take a lot of young folks. We take a lot of folks that are in their retirement age and everybody in between. But the perfect relationship is handling it in a way that is the best for the referral attorney. And I think we do an amazing job of doing that. And that's what we've just discussed, right? Is the flexibility that we have with our referral counsel, with fee structures, with cost structures, and with how we handle them.
Kaci, you were in the in-house world before you came over to do this. I mean, what's your advice to those that were like you, or that are like you used to be in the corporate world, if they run across a friend that's got a medical malpractice case or a horrible car wreck or whatever? What's your advice to them?
Yeah, I think most in-house attorneys are dealing with a lot of different issues. They don't have the litigation resources that any of us do here. And so if they hear of a case, they just don't have the support that we do. And so referring it to a litigation-based firm is the best thing you can do for that client. And ultimately, that's the point, is doing the best for the client. And if you don't have the resources to do it, finding a firm that does.
Sarah, what if you don't handle personal injury and you handle other case areas? What are your thoughts on referring those personal injury cases?
Yeah, we're all supposed to be able to handle any case that might come across our desk, but knowing your own limitations, I think, is what makes you a great attorney.
Yeah.
So if I'm not the one for the case, finding the attorney with that skill set, or that, the attorney that handles those on a daily basis is best for the client.
Yeah. What if, like, a divorce attorney or criminal attorney, they start taking personal injury? What might be your advice to some of those folks who specialize in other areas?
Yeah, I think going back to kind of what you guys were saying, they're just starting out in that area. They might be really experienced in divorce and criminal defense, but if they're starting out in personal injury, referring a couple of those cases to us and kind of working with us, seeing how it's done, might be a great opportunity for them to figure out the personal injury world.
Yep.
And I think this is hard for a lot of lawyers to swallow, but a car wreck is different than a medical malpractice case. A medical malpractice case is different than a nursing home case. A nursing home case is different than a slip and fall.
Great point.
A slip and fall is different than an aviation case, right? And so if just because you handle one or some of those doesn't mean you can handle them all, or you even have the bandwidth to do it. So that's what we're here for. We're fortunate enough to have a large team of people that has handled a lot of different things, and again, I gotta go back. A trucking case is not a car wreck, right?
Right.
So just know your limitations, like you said, and know what you've got, know what resources you have available to you, and let us be one of those resources. We're just another tool in your toolbox. That's what we are. You don't lose your client. You don't lose the fee. You just share the fee and you share the client.
Right. Client gets more typically. Is what
Absolutely.
ultimately happens.
Yeah. Maximize the fee. There's more to go around for everybody.
100%.
Last question, and I want one from each of you guys. What's the one thing that you want attorneys listening to take away from what we're talking about today?
From what I've been talking about, tracking down policies is a skill. Tracking down all applicable umbrella, anything that's out there is a skill. It's not luck, like we said. So we have, like we said, a bunch of skilled attorneys who've been doing this for a really long time who might have seen a different policy than anyone else and say, hey, that language is different. I think there might be something else there. And so that's a skill, not luck. And we've got those skills.
Right. I mean, whether it's a reimbursement policy or a fronting policy or an umbrella policy or whatever. I mean, we got people that know.
Self-insured retention, all of it.
Right. Kaci, what about you?
I think I would just emphasize the timing angle. What you do in week one and forming that foundation for your client is going to build your success throughout the life of the case. All of the details and information that you learn in that first probably 90 days, like we talked about, that's really going to set you up for success.
Yeah, and look, if you've got a client that you think can benefit from our being involved, that's another added thing you're giving them is additional people on their case that makes them feel better about being handled correctly. It's not just you as a solo or you as somebody who's busy doing a bunch of other things. You got all of us. Justin, what about you?
Our ultimate charge to our clients, every attorney's ultimate charge to a client is to do what is in their best interest. And as we have discussed today, there are certain acts that we have to engage in to act in our client's best interest, whether it's spending a lot of money on a case, whether it's hiring experts, when to hire experts, the skill in finding policies, all of these different things. If you are going to do what's in the client's best interest, that is maximizing recovery and doing it in the most efficient way. And that's hiring law firms that handle this day to day that have proven results in doing so. And so sometimes instead of just keeping that case, referring that case is absolutely in the client's best interest.
So for those attorneys that are listening to this today, one, I'm sorry, but two, look, here's what I want you guys to take away from it. This isn't about whether or not you're a good lawyer. There are outstanding lawyers that settle cases for fractions of what the cases are worth. And they never find out because they didn't know better, right? It's just not in their wheelhouse. That's okay. The coverage was there. The damages were provable. The case was worth 8 times the offer. But proving that takes a coverage investigation, thousands, tens of thousands, sometimes hundreds of thousands of dollars of expert costs, or 3 years of willingness to try the case. If you don't have all of those things, the number you get is the number that they offer you. Yeah. That's the not fair part. 2 people, same injuries, same facts, completely different lives afterward based on an infrastructure neither of them knew existed. That's what we can provide to you and your clients. All right, Justin Peterson, Sarah Cooley, and Kaci Christopher, thanks for being here. This is It's Not Fair, a podcast about moments that determine outcomes before most people know the game started. I'm Masten Childers. If you've got a case on your desk right now and you're not sure what it's worth, that's a conversation worth having before you respond to that offer, not after.